Your arraignment is your first formal court date after being released from jail. For many, this is the most stressful part of the early legal process. But before you panic about walking into a courtroom, we need to answer the most critical question. Do you actually have to go? The answer depends entirely on one factor. Do you have a lawyer? If you have already hired a private defense attorney, your experience will be fundamentally different. In Florida, under Rule of Criminal Procedure 3.160, your attorney can file a waiver of arraignment. This means your lawyer files a written plea of not guilty on your behalf. Once this is filed, the court removes you from the docket. You do not need to attend. You stay home, go to work, and live your life while your lawyer handles the procedural work. Even though your arrest paperwork says the date is mandatory, once that waiver is filed, that date no longer applies to you. Now, if you do not have a private lawyer, listen carefully. You must attend. This is not optional. Failure to appear without an attorney having filed a waiver results in immediate consequences. A failure to appear goes on your record. The judge will almost always issue a warrant for your arrest, known as a capias, and your bond could be revoked. If you are going alone, here's what happens. First, they call the docket. You step forward when your name is called. Next, the charges are announced. Be aware, these might be different from what you were arrested for. The judge will advise you of your constitutional rights, ask you to enter a plea, and then set your next court date. When the judge asks how you plead and about your lawyer, keep it simple. If you want a public defender, say, "Your Honor, I plead not guilty and I would like to apply for the public defender." If you need time to hire a private lawyer, say, "Your Honor, I plead not guilty and I am requesting more time to hire an attorney." Whatever you do, speak clearly and confidently. Here is the most important rule. Never plead guilty or no contest at arraignment. You have not seen the evidence yet. The prosecutor hasn't shown you police reports or videos. If you plead guilty now, you are pleading blind. Pleading not guilty does not mean you are lying. It simply means you are preserving your rights while your case is investigated. It is important to know what this hearing is and what it isn't. An arraignment is just a procedural checkpoint to get the case started. It is not a trial. It is not the time to argue your case, present evidence, or tell your side of the story. Save that for your attorney.